Robert Gray v. Sumter County Farmers Market.
May it please the Court, my name is Skip Dalton. I'm appearing this morning on behalf of the heirs of Cali Law and Castillo Law with Mr. Carlisle. And may it please the Court, Counsel. Your Honor, the salient facts in this case are that Cali Law and her heirs have been the record title owners of a parcel of property in Sumter County for the past 65 years. Cali Law delivered title by warranty deed to this property to her daughter just prior to passing in May of 1973. The additional salient facts are that there is no deed or document by which the appellee, the Farmers Market of Sumter County, claims title. There is additionally no evidence in the record that the Farmers Market did not occupy this parcel of property with the permission of the owners, and in fact the only evidence on the issue of permission is that permission was given. The appellant would assert that the trial court committed...
Well, let me stop you for a second, Mr. Baldwin. When you say there was no evidence except that permission was given, how do you account for the change on the tax rolls that occurred in 1948?
I think by the testimony of the plaintiff's own witnesses, the inference is that that had to have been a permissive act, because the testimony from the experts presented by the plaintiff was that at that time, in order for that lessening off of the property from Cali Law tax rolls to the tax rolls of the Sumter County Farmers Market, it would require both parcel owners to present themselves at the appraiser's office and to give instructions for that to occur. Certainly, it is equally...
Isn't that evidence, whether it's believable or not, isn't that evidence of something other than a permissive use?
No, sir. I would suggest that it's actually evidence of a permissive use. The fact that Cali Law, at least if her testimony is to be believed, had to present herself there and to agree to have that property taken off her tax rolls and put on the tax rolls of the Sumter County Farmers Market.
But doesn't that infer a sale more than permissive use?
Well, there's no evidence of a sale here, Your Honor. In fact, the record is quite clear that
Well, wasn't there some testimony that Mr. Laws said he sold the property?
Well, the question of whether or not that's actually in the record, now this was a non-jury trial, but I would submit that the record is very convoluted from an evidentiary standpoint in terms of what came in and what was kept out. But at least in the final judgment that was entered by the trial court, there is an indication that Mr. Clemens testified several different ways. In one instance, he testified that there had been a purchase, although if you look at the record, there's a lot of confusion about whether it was the purchase of this parcel or another parcel that the Farmers Market had acquired. And Mr. Clemens also testified that the Farmers Market was occupying this parcel with the permission. Now, the one thing that we do know as a matter of law is that certainly as this case began, the presumption was that this was a permissive use, that the Farmers Market was occupying this property subordinate to the interests of the record title owner, Cali Law.
Well, let me ask you one question about this lady named Castella.
Yes, ma'am.
Apparently, you say in your brief in 1982 she became aware that there was an issue about ownership.
Yes, ma'am. That's what
She began writing, her attorneys began writing letters.
Yes, ma'am.
So why could adverse possession have started then?
No, ma'am. Not at that point in time, because if you look at the totality of the evidence, in 1973 when Castella came into possession of this property, she came into possession of this property by warranty deed from her mother. Going back to the earlier point, the court found that the mother, Cali Law, was an intelligent woman, not subject to be taken advantage of. And so if she deeded the property to her daughter in 1973, that certainly suggests that at that time she still thought that she owned it. The presumption in this Castilla Law was still a record title.
I guess my point is, why couldn't the adverse possession have started running then in 1982 when she became aware that obviously farmers claimed it as its own?
Well, at that point in time in 1982, they still would have been required to meet the statutory requirements.
Didn't they?
No, ma'am. I don't think they did. I don't think they ever did, frankly.
The property was returned for they've been paying taxes. Property was returned for them to pay taxes on this particular area, and it was then well fenced by a very high chain link fence.
Well, I think that
frankly, blacktop?
No, the blacktop is not in dispute, but the testimony with respect to fencing, I would submit, is very to use the language of the case, is very loose and uncertain and requires you to resort to a lot of conjecture about what
Maybe in the old
fence
days, but wasn't there evidence that this chain link fence on 3 sides was there, a high chain link fence?
There was evidence that there was a chain link fence installed sometime in the 80s, yes, ma'am. But there's not definitive evidence.
Why wouldn't
that
that be a
it's been
sufficient
installed.
time to have the 7 years run?
Because they still haven't overcome the presumption that their initial occupation, and there's not any evidence in the record that at least I'm aware of the content of these letters as to whether or not this was just a question about the ongoing usage. We don't know, for instance, because the record's silent on it, whether or not the long-term payment of taxes by the Sumter County Farmers Market was in lieu of rent. We do know, for instance, that Mr. Clemens testified that there was permission given for the Sumter County Farmers Market to use the property for picnics and to come into the property on occasion, and whether that use simply blossomed over time. You go back and you look at the Benz case from this court, I mean, it's quite clear that this presumption of use exists and that the responsibility to overcome it is to present clear and convincing evidence that does not require the resort to conjecture in order to establish possession under the adverse possession statute. And clearly there is no evidence in this record to overcome that fundamental presumption. It actually looks like, even though I don't mean to be presumptuous about how the case was tried, but it actually looks like, when you look at the entire record, that the case was tried under sort of the old notion of lost grants, because there's a lot of testimony about the length of possession. There's a lot of testimony about, the nature of the use and the openness of the use and the notorious nature of the use. But there's no evidence that touches on how it is that relationship had its origin. Maybe it's because, of the time that passed. But clearly, when you look at the evolution of the case law with respect to maintaining a claim under adverse possession, this old notion of lost grants certainly has no application in the law today. As the court is aware, the lost grants notion would be that the wrongful occupier, essentially if they've used it openly and notoriously for an extended period of time, that the burden now, shifts to the title owner to show that, the wrongful occupier doesn't occupy it under some grant, or to Judge Sharp, back to your point as to whether or not perhaps there was a purchase of the property. In the absence of any evidence of that, as we know from the current case law, is that responsibility to overcome the presumption of permissive use by clear and convincing evidence rests upon the plaintiff, and it's quite clear that the record here...
Well, here's some circumstances. This thing is blacktop. It's fenced off from the law's heirs. I mean, they can't get to this property from their property anymore. They don't use it anymore. They've moved their house. They don't try to use it anymore. And they couldn't use it if they wanted to because it was full of cars, trucks, and things. I mean...
Well, I would respectfully disagree. There's evidence in the record, in fact, that the children growing up did use the property. There's evidence in the record from one of the children, Mimi, I've forgotten her last name, Mimi Sheehan, I think, that when she was living there, that the children used it. They played hopscotch on the property. They played ball on the property, that there were no signs saying that they couldn't come on it. There was no one ever asked them to leave. There was no suggestion that they were trespassing on the property.
But they didn't farm it anymore, didn't they?
They did not cultivate it, that's true, but I don't think there's any indication in the record that this particular plot was ever cultivated.
And wasn't there a fence put down between the law's remaining property and this blacktop? Well,
the fencing issue is very difficult to sort out from the record, but there was a hog wire fence, or an American fence as it's been called. Really, the record is not clear as to whether that was put up by Millard Law or Callie's husband. At what point in time did that, there was a lot of testimony that the townsfolk walked across that property in order to get to town. They went through gates during some parts of time.
So what's your basis for appeal as to the trial judge's final order? In it, he looks at the alternative theories and he goes through them carefully. He looks at the tax roll, the testimony of the experts as to how land was surrendered, how it was transferred on the tax rolls. He looked at the fencing, the improvements, the lime rock, the blacktop, the American chain link fence. So any time from 1948, would you agree that if you have 7 years, that gives you the time period under statute, along with the improvements, open and notorious, the fact that the house was moved 660 feet to show that they own the property, they being the appellee?
Well, Your Honor, with all due respect, none of those factors are dispositive unless you can establish adversity in the first instance. And we know that adversity, by definition, requires that the presumption of permissive use must be overcome. And the court, in fact, if you look at paragraph 20 of the court's final judgment, in the final judgment, the court notes that Lloyd Clemens, one of the founding fathers of Sumter County Farmers Market and prior director, stated in his testimony that the farmers market had permission to use the disputed parcel. If, in fact, they had permission to use the disputed parcel, as by operation of law, it cannot be an adverse possession. So the failure of the plaintiff to establish the essential element of adversity is fatal to their case. Now, we know, again, not to
What level of proof is required?
clear and convincing evidence, Your Honor. Clear and convincing evidence is required to establish.
Didn't the judge in paragraphs 28 through 30 dispute the fact that you have, or refute the fact that you have? And the point is, where did the judge err? He had testimony, expert witnesses, people who would live a long time in this area, people who grew up as children in this property, and they talked about the improvements, filling in a gully, blacktopping, lime rocking, et cetera, et cetera, et cetera. Where did the court err? And that's, in essence, what you have to say the court did.
And the court did err because the openness and the notoriety, the extensiveness of the use of the property is not germane to the fundamental issue of adversity on the question of permission. That, I would submit, is the error in terms of when you look at the totality of the record in this case. A whole lot of testimony and a whole lot of time and attention was spent on establishing those criteria, which is why I suggested that it actually looks like the case was kind of tried under a theory of lost grants, and that's not the law. You know, the law is that it's incumbent upon the plaintiff as a threshold element to establish that they were not. And for instance, we don't know what.
In any kind of adverse possession case, how could you refute a person who came up and said, well, I let them do it, and it was okay with me, but they understood that they didn't really own it. We were just allowed to do whatever they want to do there, but it's still my property.
Well, I mean, if you look at the language in some of the cases, there's no suggestion in the law that you run the risk of giving up your property by being neighbors, or that you run the risk of losing title to your property by allowing your contiguous landowner to accommodate his or her interests. And in fact,
that's okay if you're sharing cattle or you're running cattle in the same land or allowing cattle to water, or allowing people to go across to get to a piece of property. But when you start making improvements, putting up fences, blacktopping, excluding the owners, and the owners then move from the section where you now have acquired some kind of possessor or interest, isn't that a refutation of your argument, well, it's just part-time, or it's just temporary, or it's just with my permission?
no, sir, because we have to, in order to get there, we have to make assumptions and we have to engage in conjecture, and that's not, the law doesn't permit that. The law doesn't permit us, for instance, to assume that the relationship between Cali law or Castillo law, or any of the law areas for that matter, was anything other than permissive in the absence of direct proof to that. And it must be clear and convincing evidence to that.
Well, let me ask you, Mr. Goldman,
Yes.
Would you agree that the same evidence can actually impact both parts of the case? That is, the same evidence can affect whether or not it was a permissive use and whether or not the criteria for establishing adverse possession were satisfied. In other words, would you agree that enclosing the fence might also have an impact on, or might also be evidence of the absence of permission?
I would say that it could be considered as circumstantial evidence with respect to, what the intention of the parties was. But going back to the question Judge Thompson asked, I don't think the record is at all clear here about the exclusivity, for instance, the exclusivity of the use. The testimony in the record with respect to what was fenced, what wasn't fenced, whether there were gaps in the fence.
Yeah, but we don't have to necessarily segment the evidence to one issue or the other. The same evidence can impact both issues.
I think it can. I think it can. But I think in order for you to get to, for instance, the substantial enclosure aspect of the argument, which is discussed at some length in our brief and the brief of the appellee, before
Is it
you
your position that it has to be enclosed on all four sides?
I think it has to be. It has to be substantially enclosed, and that, whether or not the substantial enclosure is in fact sufficient to meet the statute, I would concede that is an element for the fact finder. But it has to be established by clear and convincing evidence that's not loose and it's not uncertain, and that does not put you in the position of having to resort to conjecture. I mean, it's clearly what the case is saying. And if you look at the totality of the evidence in this case, I would respectfully submit that there's nothing tight or certain about the evidence in terms of what was enclosed, when was it enclosed, the exclusivity of the use. For instance, this is, by its nature, it's open to the public during certain parts of the farmers market operation, but the evidence is also clear in the record that townspeople went onto the property, people went over the fence, that there were gaps in the fence. During some sections of time, the fence was up, or in other sections of time, the fence was down. So I would respectfully submit that if you don't get there, obviously, unless you're comfortable, the record establishes this question of adversity. And if you don't meet the threshold element of adversity, you never get to the question of whether or not the substantial enclosure was.
Counsel, you're about 4 minutes. Got about 4 minutes left. Would you like to reserve some time?
For a while. Thank you.
Right.
May it please the Court. My name is Marcy Lippincott. I'm here today with co-counsel Larry Marchbanks, representing the Sumter County Farmers Market. Your Honors, it's important to understand that the testimony with respect to the change in the tax roll is not as appellate counsel represented. There is absolutely no testimony in this record that Cali Law had to agree for the Sumter County Farmers Market to assume payment of her taxes. That was not the testimony. The testimony was that she or her representative had to go to the courthouse and ask them to excise or take away the blacktop from her taxes. On the other hand, there's testimony that Sumter County Farmers Market had to send a representative to the courthouse and say, we want to pay taxes on the blacktop. There is no testimony in this record that Cali Law had to agree for the farmers market to do that. In fact, that would be impossible, because if that were the standard, then you could never meet the standard for adverse possession, that is, returning a property for taxes, and not take away from the requirement to show a lack of permission. The two are contradictory. You couldn't have it. Your Honors, there is simply not a case that you can find out there where there is more evidence that meets all the requirements of adverse possession than this case. In this case, we have over 50 years where the Sumter County Farmers Market has returned the property for taxes each and every year, has paid taxes on the property each and every year. The evidence is abundant here that it is the Sumter County Farmers Market who has acted as the owner without permission. Sumter County Farmers Market was the owner. And when we're talking about adversity, it's important to understand it's not necessary to have ill will, anything like that. It's simply necessary to act as the owner. And the testimony was replete here that Buddy Tompkins, whose family owned a restaurant near the blacktop, he had knowledge of this property since 1945. He knows that the laws took their house and moved it, literally moved their house from the blacktop to the rest of the property that they did pay taxes on. He knows at that point in time they were farming the blacktop. Suddenly in 1948, no more farming. Their farming operations moved to their property. And he knows that what that property was used for was it was used for the farmers market for parking. He also told us that the gully was smoothed over, compacted. The land was made compact for the parking lot. We have Mr. Akins, who was chairman of the board of directors of the farmers market since 1963. He testified that from his earliest recollection of the blacktop in the mid-50s, the farmers market has always treated the blacktop as if it were the owner. It possessed it. It paid the taxes. It improved it. There were fences. The only fence that was removed was the fence that separated the farmers market property from the blacktop. Purpose being so the farmer's market could use it to park there. The evidence from all of the plaintiff's witnesses was that a substantial enclosure remained around the other three sides, and indeed in the 1980s was replaced with an 8-foot-high chain-link fence. What more could you do to show ownership, show propriety, than what we have here? The evidence was simply overwhelming in this case, that the Sumter County Farmers Market has done everything possible within the requirements of the law to meet those requirements of adverse possession. All the issue here before you is simply whether or not there was sufficient evidence. There was the sufficient evidence. There should be no question. I can tell from your questions that you understand that. So therefore, unless you have any further questions for me.
What do you do with the testimony of Mr. Clemens, who said it was permissive?
Yes, Your Honor. You can do one of several things with that. First of all, if you read Mr. Clemens' testimony, I know that the judge included his testimony, that little reference, in the final judgment. And you'll also see in the final judgment, and when speaking of Mr. Clemens, the judge also said that Mr. Clemens said that the market bought the property. And if you read his testimony, you see that Mr. Clemens said the market bought the property in 1937. No, maybe it was 47. No, maybe it was 63. So that you see that Mr. Clemens was a little confused about when the market bought the property. But you do as the trial court judge did here, and you look at all the other evidence in the record, and everything changed in 1948. It didn't change in 1963. In 1948 is when the laws moved their house. It's in 1948 when Cali Law had to go to the courthouse and say, I don't want to pay taxes on the blacktop anymore. It was in 1948 when the Sumter County Farmers Market went to the courthouse and said, we do. We take responsibility for the blacktop. We want to pay taxes. So all the other evidence in the record makes it seem like Mr. Clemens may have just made a mistake with respect to the date, and it was really 1948, not 1963. In addition, there's another way to deal with Mr. Clemens' testimony, and that is simply the basis of the tipsy coachman rule. In fact, we don't even have to do that, because all we have to do is look at paragraph 33 of the court's final judgment, where he concludes that there are other years that meet the requirements for adverse possession. Any 7-year period would be sufficient, but he points out specifically 68 through 74. And of course, you remember at that point in time, even Mr. Clemens agrees that the farmer's market had bought the property, because he says from his memory that took place in 63. So from 68 through 74, we have all the elements. The farmer's market returned the property for taxes, it paid the taxes, it possessed the property as its own. The area was substantially enclosed, improvements were made, a drainage system was installed, it was asphalted during that time period. There's simply no question but that all the requirements would have been met, at least during that period. So that's how we deal with Mr. Clemens.
I think some argument was made in the appellant's brief that this adverse possession time had to start running in 1948.
Well, I would take exception.
And I don't understand that argument. Could you help me out with that?
I don't understand that argument either, Your Honor, because if you look in the record, you'll understand that Mr. Levi testified that the tax rolls provided the only written evidence that property has been returned for taxes. The tax rolls from 1947 to 56 were admitted into evidence here as plaintiff's exhibits 1 through 10. In addition, there was a stipulation between the parties that all the tax rolls since 1948 have remained the same. And if you go and you take a look at those tax rolls, there's a column number 5. It's entitled Name of Owner or Person whose name return is made. And in that column number 5, for each and every year since 1948, it's the name of the Sumter County Farmers Market that is there, that shows that Sumter County Farmers Market has returned this property for taxes each and every year since 1948, exactly as was pled in this complaint. So therefore, each and every year they met that requirement, so you can take any 7-year period since then. And it's clear that the farmers market has exceedingly met their burden here, and there's simply no question but that this judgment should be affirmed. Anything further, Your Honors?
I guess not. Thank you.
Thank you very much.
All right, Mr. Dalton, you've got about 4 minutes, 4.5.
We still haven't heard where in the record the presumption of permissive use has been overcome, or what evidence there is on this question of permissive use, and that is, frankly, the 500-pound elephant that's in the middle of the room. Where is the evidence on this? I want to go back to the point that was made by the appellee with respect to this evidence about what happened in 1947 or 48 with respect to the tax roll. During this section, it's on. I apologize, I don't have the record citation. It's page 59 of the trial transcript. The court asked the question of the witness. So I mean, he couldn't have done that on his own, talking about adding or deleting the east half of the property. The witness. Yes, sir. The court. So I mean, he couldn't have done that on his own. The witness. You could not have done this on your own. No, sir. The assessor had to do that. The court. Somebody had to give him that instruction. It had to be two people. If I understand what you said earlier, had to be one for each property owner had to have a representative to make that request. The witness. Yes, sir. Understand, these were just parts of huge books. Now, what is the significance of that exchange? The significance is that we know that presumptively that this occupier of the land occupies it subordinate to the title of the record title owner. We don't know because there is no evidence as to what the nature of the agreement was, if any, between Cali Law and the Sumter County Farmers Market back in 1947 or 48. It is equally as plausible, I would respectfully submit, that Cali Law, in lieu of maybe couldn't pay the taxes or didn't want to pay the taxes and agreed that they could use the property and pay taxes in lieu of rent. There's no evidence to suggest that, but there's certainly no evidence to suggest that that wasn't the case. You have to look at that now in light of what happens subsequently. In 1973, this woman this Cali Law woman, who is by the court's own finding, and a smart individual, grants by warranty deed prior to her passing this property to her daughter. That certainly does not suggest someone who thought that they no longer owned the property, or that they had either given it away or abandoned it or sold it, because there's no evidence in the record to suggest that. There's evidence in the record that they moved their home. That's fine. That's all well and good. Again, there are lots of other plausible explanations for why they might have done that, including, we don't want to give up this property. We can't afford to pay the taxes on it, but if you will, we'll make it more convenient for you. What we do know is that the law is quite clear that when property rights when property is being taken from one individual who is the record title owner, whether it's by prescriptive easement or whether it's by adverse possession, that the burden is extraordinarily high, and that there must be clear and convincing evidence on each and every element, whether it's 7 years, whether it's 65 years. And the fact of the matter is that in this case, the essential element of adversity has not been established. The trial court committed error as a matter of law in finding adverse possession and in quieting title in favor of the Sumter County Farmers Market in the absence of proof on that issue, and we would respectfully submit that the case should be reversed.
Other than the fencing, do you dispute any of the facts about the blacktopping, the property being improved, taxes being paid, starting from 1948?
Certainly not the tax issue, Your Honor, and with respect to the other issues, the only point being is that, frankly, there's certainly no tight and certain evidence about this issue of substantial enclosure or improvements in terms of when they occurred, to what extent they occurred, but I certainly don't dispute that the farmers market occupied, paid taxes on, and periodically improved the property during that 65-year interval.
Let me ask you one question I asked your opposing counsel, which is, why is it your theory that this 7-year period of adverse possession had to start in 1948?
Well, because by statute it has to start within 1 year. Within 1 year of taking occupancy and returning the property for taxes is when the 7-year period must begin. If you look at 95-18, which, by the way, we miscite in our brief as 98-18, but we've corrected that. But in any event, you look at what happened at the law at that point in time, is that it was recognizing that a property owner has to, first of all, return their property for taxes, and within 1 year of occupying the property.
They did that.
Well, it's a question of whether they did that. I mean, I don't think it's a huge question, but what does return property for taxes mean in 1947 or 48?
Apparently what they did.
Well, you had an expert testify as to what it meant, and testifies to the form subsequently that clarified the law in that area as to make sure that there's no misunderstanding.
But does
And I don't
that,
dispute that aspect of it. What I guess I dispute is the effect of that. You know, the effect of that return at that point in time. Paying taxes, as is clear in the law, doesn't give you the right to, it doesn't give you ownership in the property.
Right.
Thank you.
thank you. That will end our session for the day. Thank you.